Hello, this is Tina Gote, and I am presenting a gender discrimination discussion board post for EDA school law. The case summary that we're discussing is about a teacher who's employed as a French teacher at West Point High School, and he has a contract guaranteeing employment through 2018-2019 school year. He refused to use male pronouns for a transgender student, Doe, who recently transitioned from female to male. He used female pronouns for Doe, citing religious beliefs. Despite multiple attempts to address the issue, the school placed Fleming on administrative leave and issued a formal reprimand and recommended for his termination. He was fired for violating the school's non-discrimination and harassment policy. Fleming filed a lawsuit claiming violations of his religious freedom, free speech, and due process rights, including a breach of his employment contract. The legal questions presented here are: does the teacher's refusal to use pronouns match the student's identity violate his religious freedom rights? Does the teacher have free speech rights to refuse? Is the teacher's termination in compliance with Florida's Just Cause employment standard? And did the teacher's actions violate Title IX by discriminating against the transgender student based on his or her identity? The findings for this case are: the court filed in favor of the school, that their actions were justified under federal and state anti-discrimination laws under Title IX, prohibiting discrimination based on gender identity, and the school was acting in its legal obligation to prevent discrimination. The reasonings for this: under religious freedom, the court balanced the teacher's religious rights against the school's interest in preventing discrimination. While Fleming has the right to his religious expression, the school's policies were aimed at ensuring an inclusive, non-discriminatory environment. Under free speech, the refusal to use pronouns that match the gender identity violated the First Amendment rights of the student, and the school's responsibility to protect transgender students under Tinker v. Des Moines of 1969 established the First Amendment rights may be limited in school settings if their expression disrupts the educational environment. Under just cause for termination, Fleming's refusal to follow school's directives after multiple warnings constitutes insubordination, which are grounds for termination under applicable laws and employment standards. Title IX violation. Fleming's actions constitute discrimination based on gender, which is prohibited by law. Title IX prohibits discrimination on the basis of sex in educational programs and activities. To answer the following questions: does the teacher have a claim in regards to using the pronouns the student identifies with against his religious freedom? Fleming claims that the use of pronouns violates his religious freedom under the First Amendment. The Free Exercise Clause protects the individual's right to act according to their religious beliefs, but this right is not absolute. The school has an interest in preventing discrimination, and the teacher's refusal to use the correct pronouns creates a hostile work environment. The school's policies supersedes the teacher's beliefs as they conflict with federal and state discrimination laws. Does the teacher have a free speech right? The teacher's right to free speech is protected under the First Amendment. However, there are limits for public employees. In this case, the teacher's right conflicts with the educational mission of the school, disrupting the learning environment. The school has the responsibility to protect and provide a safe, inclusive learning environment, and this is more important than the teacher's right to refuse to use certain pronouns. Does his termination meet a just cause in the state of Florida? Is it a breach of his contract? Florida Public school teachers are considered at-will employees, meaning they can be terminated for any reason that does not violate public policy. In this case, the teacher's refusal to follow school policies can be viewed as insubordination, misconduct, and a failure to follow administrative directives, which is considered a breach of contract. Therefore, just cause is supported. Is the teacher entitled to due process if terminated? Under the 14th Amendment, public employees who have property interest in their employment are entitled to due process. In this case, the teacher was notified of the charges, provided an explanation of the evidence, and provided the opportunity for a hearing. The formal reprimands and final warning and hearings meet the requirements for due process. Therefore, procedural guidelines were met and his termination moved forward. Does the teacher's actions violate Title IX? The teacher's refusal to use student preferred pronouns may be a form of discrimination under gender identity. The schools are required to provide a safe, non-discriminatory learning environment for all students. Title IX especially addresses gender discrimination. Courts have extended this protection to include gender identity. Therefore, the teacher's refusal constitutes a form of discrimination based on gender under Title IX. So yes, this was a violation of Title IX. This concludes my post for today. Thank you and have a good day.